last, I'll start again since we've just started recording. Thank you, everybody. Welcome to our last panel of this conference. Earlier in the day, we started out with panel 3. And what panel 3 did was they helped us to, they discussed international investment agreements and how those can support the development of African states. And they also engaged a little bit with the Africa Continental Free Trade Area. So we moved from, sorry, that was yesterday. So today's panel 3, we started with the African states and international investment arbitration because we entered dispute resolution today. And so they explored various cases and talked about how prepared African states are with their engagement in the international investment arbitration arena. We then moved on to look at the African states and their promotion of mediation, both domestic and cross-border. And we also explored the Singapore Mediation Convention. We have the mediation network. And so they had done some survey and they presented, gave us a presentation of their findings. So we're now back to our final panel of the day. And like I said before lunch, the purpose of this panel is to move us away from dispute resolution to how do we avoid getting into disputes in the first place. And to chair this panel, which I'm also going to be speaking on, is Marie-Andre Ngwe, who is a legal practitioner in Cameroon, in Douala. She hosted us with CIMAG at our Douala conference. The full bios of Andre and her panelists is on the website. I've put that in the chat. We will try and I understand, I know that Andre is going, our moderator is going to be speaking in French. Some of us would speak in English, others will speak in French. So we have the perfect panel that represents the continent. The only 2 languages, formal languages that we do not have on this panel, is not as though we can't speak it, is Arabic and Portuguese. So I would hand over to Marie-Andre, and at the end, she will hand back to me. We will have a poll. And when we finish, we would have our closing ceremony, which basically the committee that would organize our conference next year would speak and invite colleagues to the conference. Andre, Marie-Andre.
Merci, merci Emilia. Est-ce que l'interprétation marche? J'ai pas l'impression. Est-ce que vous, do you hear me in English? Because I do not see the interpreter in French.
So I saw the, yeah, I have the English version.
Je peux vous dire, sans avoir peur de vous donner de mauvais chiffres, que 100% des cas où j'ai visité les prisons, ça faisait partie de mon travail de mener des inspections dans les prisons et pour mener des interviews avec des personnes incarcérées.
Oh, okay. The interpreter sent a message. Okay, I think, CIMAC is on it. Our colleagues looking at that. I think the interpreter is still locked out. He came back late from lunch. So they're just letting him into the room. So we should be able to start shortly. Perfect. We have the second one.
And we hear another conference. We hear, so there's a problem with
Can you hear me now? Can you hear me now?
Afin de reconnaître. Je pense que beaucoup des questions ont déjà été anticipées. Vous savez déjà, vous connaissez déjà les réponses à ces questions. Mais j'aimerais quand même entendre vos réponses et après cette diapo, nous allons avoir un petit exercice rapide aussi. Donc, quels sont les droits de l'homme des agents frontaliers, des agents de frontières? Quel type de droit d'homme?
Can I suggest that you start and then let's see whether we'll get the English translation?
Quels sont les droits de l'homme dont bénéficient les agents?
No, start in French, because the French guy is there.
OK.
Thank you.
Bonjour à tous. Tout d'abord, merci à Emilia et à CIMAC pour leur invitation et pour cette belle organisation. Je voudrais spécialement féliciter Emilia pour son action.
Emilia for her action and creating a unique community of arbitration.
Continent. C'est le dernier panel de cette conférence. J'espère que tout le monde a encore assez d'énergie pour suivre les speakers de ce panel. Et je vous assure que l'intérêt de ce panel est très important. Il s'agit de la prévention des différends avec des suggestions pratiques et réalisables. Nous verrons aussi quelles sont les mesures qui ont déjà été prises par certains États africains. Est-ce que l'interprétation marche maintenant en anglais? OK, fine. Nos panélistes vont donc intervenir dans l'ordre suivant. Tout d'abord, Dr Emilia Onyema, ensuite le docteur Amadou Dieng, puis le docteur Ismaël Selim, ensuite Madame Lise Boseman et le monsieur Hussein Haeri. Je vais donner à chaque intervention, je vais dire quelques mots sur le speaker, mais vraiment juste quelques mots parce que les biographies sont disponibles sur le site de CIMAC et sur le site de SOAS. Chaque speaker va intervenir en 15 minutes et après les interventions, il y aura une session de questions et réponses. Merci aux participants d'envoyer vos questions au fur et à mesure et, si possible, de dire à qui vous posez la question. Alors, notre premier speaker est Emilia, que tout le monde connaît, qui est professeur de droit commercial international, qui est avocat au Nigeria, en Angleterre et au Pays de Galles, et qui est un arbitre international indépendant reconnu. Elle est aussi l'initiatrice des conférences SOAS. Emilia, the floor is yours. Vous avez la parole.
Yes. Thank you very, very much, Marie-André, for your very kind introduction. I'm not going to speak for 15 minutes.
Je n'ai pas l'intention de parler pour 15 minutes parce que je veux établir
can better prepare for the negotiation of contracts and investment treaties and the role, if any, that model treaties can play in dispute avoidance. Our panel, the goal with the task ahead of this panel is for us to explore how African states can avoid disputes. We all know that African states are involved not only in investment disputes, but even in contractual disputes. We have state contracts, we have national investment laws as well. We have regional trade agreements, and all of this, we have disputes arising. And one of the questions I think we need to ask ourselves is, why do we have so many disputes arising? And if one of the panels today looked at this particular question, and one of the speakers will ask the question, why do we have African states having so many investment disputes against them? And they gave various reasons. I'm not going to rehash the reasons they gave, but one reason that stands out to me, two points that I want to pick up from that is, the first one is this whole idea of not abiding by contractual provisions. So we know for a fact that African states would sign up to or make commitments or promises that somehow they're not able to meet, and not having a proper structure for either re-engaging, renegotiating, or let's just use the word re-engaging with the other party to try to see how they can sort out what that difference or their lack of ability to perform their undertaking. So there is a serious concern with the inability of African states and agencies to comply with undertakings that they themselves have given. And the second concern flows out of this first concern, which goes back to the question we can, whether African states promise too much, and whether we even understand what it is that we're promising. So this morning, panel 3 talked about, one of the speakers explored, just took Turkey, the president of Turkey, and when the president of Turkey visits an African country, in less than a year, in the same year, an investment treaty is signed with Turkey without the public knowing that there was even negotiations going on, and that sort of behavior. And of course, she then asked, when was this negotiated? Was it even negotiated to start with? Or did the Turks put the agreement in their pocket? And we can use the example she used with data was Turkey, but we can say the same of China, of any other country. And so maybe that leads to the point about lack of preparedness of African states in engaging in these legal transactions. And then the third question we may want to think about and ask ourselves is whether we even appreciate the binding nature, the fact that signing up to these treaties has a contractual binding nature to it, that we can't be held to account. So it's gone are the days where we can say, well, it was just photo opportunity. We now know that signing up to all of these treaties, there's a teeth, they have teeth and they can bite. And they've been biting African states. And we heard, we got loads of examples, and we've discussed all of this already in this conference. And so one of the things I felt we should start with is maybe we need to understand how we get into disputes. What is it that makes us not as efficient as some other states? And when we do have differences or disagreements with maybe the investors, what then do we do? How do we engage with it? And that, of course, can take us back to the sense of sovereignty, you know, the big man syndrome, the idea that I am the state. Relying on the police powers of the state, I can do what I want when I want it, and nothing can be done. But gone are those days when a state can say, I have total and absolute sovereignty. I think if there's some movement away within the international legal space, is the fact that states are not, if you like, I would say it plainly, are not completely and totally sovereign. That we have limitations to state powers. We have constraints to state powers. And the question then becomes whether African states understand that that shift has happened, and that if they participate, if they make promises as the first citizen of that state, they do need to be rules abiding. They do need to comply with that transaction. Does that mean that if their condition or if situations change, that the state cannot have any wiggle room or do anything about it? I don't think so. I think what it means is that the state can renegotiate. The state can re-engage with their counterparty, but at least show that respect and that deference and have those discussions on how to move, to progress that relationship. So to conclude on that point, my view is that from the experiences and what the information we have, just looking at arbitral awards against African states, looking at the types of disputes that arise against African states, that most African states are not rules abiding, that they overpromise what they can deliver. And when it becomes really clear that they can't deliver, they then do not renegotiate or try to resolve their constraints with their partners in an amicable sort of way. So that's my first point. The second point I want to then ask, the question I want to understand is, how do African states negotiate these treaties? Do they even negotiate their international commercial and concession contracts or treaties? Can we begin to find a practice by African states? Throughout this conference, we have continued to draw the example of the Nigeria-Morocco BIT and the negotiations conducted and the provisions of the Nigeria-Morocco BIT. But we also saw this morning that other treaties concluded by Morocco within the same period do not contain the depth of detail that we have in the Nigeria-Morocco BIT. I know some of the Nigerians that were involved in the negotiation of the Nigeria-Morocco BIT. I want to just sort of draw some learnings from that. A number of those were academic colleagues who are experts in this area of the law. And they participated with the negotiating team from the Nigerian Export Commission, the Investment Commission of Promotion Commission in Nigeria. And for me, I think that there was proper negotiation. The only, if we were to fault anything, which I will come to later on, is the point on transparency. And again, opening up the discussion, sharing with the larger community the discussions around the negotiations so that we can all feed into that. That was also picked up by one of the panels this morning. This lack of transparency, but that was in the context of the negotiations around the investment protocol of the Africa Continental Free Trade Area Agreement. The fact that we really don't know who is negotiating what is being negotiated. There is no draft that is being made publicly available for interested parties to at least comment or share comments. And it's not very clear that the AU has a clear understanding that the international community is moving away from the lack of transparency. And one easy example of, or comparable example, is the Indian model BIT, which was publicly available within it for a time frame for people interested to send comments. And those are the sorts of engagement that I think would help to reduce the incidence of disputes. The other thing that we can see from the UNCITRAL practice is this whole idea of having an academic forum attached to the working group, if you like, so that the UNCITRAL can make requests of the academic forum. And maybe that's something for the African Union, the Africa Continental Free Trade Area Commission, Secretariat, and others, and African states or the regional economic communities to think about. We have expertise, both within and outside of the continent. And these experts are interested in working with states and working with governments to share with them what's the current learning, where we are at, and also proffer innovative solutions and decision-making and measures that can be included in some of these documents that are being looked at. The third point, so the answer that I have is that there is no clear negotiation practice amongst African states. It all depends on who the counterparty is. So we don't have a clearly identified or defined practice amongst African states. The next question then becomes whether why do we think that a model investment treaty is important? And that's I would answer that question before I move on to the last question that I have. So why is a model investment treaty important? And this has been overflogged. It goes back to preparation. You have to prepare. You have to know what it is you want. The panels that we had earlier on today, and even those from yesterday, kept talking about the difficulties with the content of investment treaties that African states have signed up to. And this morning we heard how most of the compensations, the heavy compensations and cases against African states are from first generation BITs. And the activity, how African states remain active and continue to make and include provisions in their IIAs that we all have difficulties and problems with. So I think that the idea of a model BIT would ensure preparation. We then begin to think about it. What do we want? What do we need? I think there's a degree of that state, understanding where that state is on the spectrum, and so that the state can determine properly what they want out of that investment relationship. Because we also have to keep in view that the investment treaty is between the states. The investor only just takes advantage of what the states have agreed. And traditionally, capital exporting states, if you look at their own model BITs, the idea is to protect their own citizens who traditionally export capital. Of course, things are beginning to change. And as things change, we can see the change in tune and the change in outlook of developed economies as it relates to international investment treaties. The second thing is that it helps with transparency. I've already mentioned that. We then know the basis on which the state is willing to transact. And now that we have indigenous peoples, communities, those that are actually impacted by the decisions that states make, they can also have a say. They can make the representations of what it is that they think and what they want to get out of it. quickly moving on, I think it will lead to consistency, consistency in provisions, consistency in decision-making, and this would also lead to certainty of outcomes, hopefully, from the decision-making from arbitral tribunals in determining or interpreting those provisions. The last thing I want to mention is the last question I want to deal with is whether African states are moving in this direction. So the direction of travel being transparency, openness, engagement with their own expert communities would be, again, opening up so that we know the basis, the terms that they wish to deal with. And we do have some model investment treaties at regional level with COMESA, East Africa Community, ECOWAS, SADC, we have those. But again, how many people engage with those? Even the Pan-African Investment Code, the basis I understand of which the investment protocol is being negotiated, you know, how many people actually contributed to the formulation of the Pan-African Investment Code. And so that for now, that is not the direction of travel, but that needs to be the direction of travel. And that would ensure that African states are focused on what it is, the investment treaty they have engaged with, they've signed up to, what benefits they should be getting from that investment treaty. This would lead to less disputes. It would lead to more conciliatory ways of dealing with disputes and when situations change. The last thing to remind what I've said is, again, it will help with what promises the states make. So we need to make promises that we can actually abide by. Thank you. Marie.
Merci, Emilia. J'allais juste envoyer un petit mot. Merci, Emilia, pour cette présentation qui pose les problèmes et donne quelques pistes. Nous allons maintenant entendre le docteur Amadou Dieng, qui est un legal advisor, médiateur, arbitre et formateur. Sa pratique comme avocat est centrée sur le droit des affaires et la conduite des procédures judiciaires et arbitrales en matière de commerce international. Il a été notamment lectureur à l'Institute of Latin America à l'Université de la Sorbonne. Il a été avocat au barreau de Paris et c'est un spécialiste du droit OHADA. C'est dans ce contexte qu'il va nous présenter les différentes innovations du droit OHADA sur l'arbitrage et la médiation. Et il va étudier leur impact potentiel sur une étendue accrue de la médiation dans le règlement des différents investissements dans l'espace OHADA. Amadou, vous avez la parole.
Merci beaucoup, Marie-André. Bonjour à tout le monde, les panélistes et les participants. Effectivement, je suis très heureux de participer à cette manifestation depuis 2 jours qui effectivement a pu mettre en avant un certain nombre de questions, mais aussi a proposé l'utilisation, en tout cas, des modes alternatifs au règlement judiciaire, notamment à l'arbitrage en particulier. Il nous a été demandé effectivement de parler de la prévention. Je vais essayer de partager avec vous le document que j'ai préparé à cet effet. Donc, je ne sais pas si vous l'avez tous. Donc, notre panel concerne les États africains et la prévention des litiges. J'ai choisi de traiter ce thème en parlant de prévention, mais aussi en surtout estimant que, au-delà de la prévention, le règlement amiable en lui-même est un instrument de prévention des litiges d'investissement et des litiges commerciaux. Je prendrai pour illustrer mes propos le cas de l'OADA, et l'idée essentielle, c'est de retenir qu'il y a eu une évolution qui me paraît incomplète et qui devrait être complétée. Dans ce cadre, effectivement, je traiterai principalement de 3 questions. D'abord, la première, c'est de montrer les différentes parties qui articulent entre ma présentation. D'abord, les mesures qui sont déjà adoptées par les États OADA pour éviter les différends, notamment le règlement amiable, comme je l'ai dit, et ensuite montrer en quoi et par quels instruments le recours amiable préalable tel qu'il est prévu dans les instruments d'investissement constitue un moyen de prévention. Et enfin, dans une 3e partie, je discuterai des suggestions pratiques et réalisables à adopter par les États OADA. Les mesures déjà adoptées par l'OADA, on en a parlé un peu ce matin, notamment avec l'adoption de l'acte uniforme sur la médiation, mais il y a eu également la révision de l'acte uniforme sur l'arbitrage et par conséquent également la révision du règlement d'arbitrage de la CCJA. Donc nous allons examiner ces 2 innovations, notamment la révision de l'acte uniforme avec l'intégration de l'arbitrage d'investissement. Et ensuite, nous parlerons de l'adoption de l'acte uniforme sur la médiation qui institue en réalité une possibilité de médiation, arbitrage, médiation, argumentale, et qui structure aussi le processus de médiation. Parce qu'effectivement, si on regarde un peu en comparant la directive européenne sur la médiation et l'acte uniforme sur la médiation, on voit bien que l'acte uniforme sur la médiation est beaucoup plus élaboré en ce qui concerne la procédure et les suites relatives à l'accord de médiation. Concernant la révision de l'acte uniforme, l'élément essentiel à retenir, c'est qu'il a été introduit au cours de cette révision un article, un alinéa à l'article 3 qui stipule que l'arbitrage peut être fondé sur une convention d'arbitrage, c'était déjà acquis, ou, et c'est ça le rajout, sur un instrument relatif aux investissements, notamment un code des investissements ou un traité bilatéral ou multilatéral relatif aux investissements. Cette introduction, effectivement, crée une dimension nouvelle par rapport au règlement des litiges dans le cadre de l'OADA, dans la mesure où, comme vous le savez, malgré tout, l'arbitrage d'investissement est un arbitrage assez spécifique, assez particulier et qui peut effectivement élargir les éléments à prendre en considération plus que dans l'arbitrage strictement commercial. En prolongement de cette modification de l'acte uniforme sur l'arbitrage, il y a eu également une modification du règlement d'arbitrage de la CCJA, notamment l'article 2, auquel il a été ajouté un alinéa qui stipule que la Cour peut également administrer des procédures arbitrales fondées sur un instrument relatif aux investissements, notamment un code ou un traité bilatéral ou multilatéral. Cela élargit notamment les compétences de la CCJA en matière d'attraction des contentieux, souvent dans lesquels les États sont impliqués à travers des investissements. Mais surtout, le règlement, et c'est là où il faut insister dans sa révision, a insisté sur le fait que, en présence d'une convention ou d'un mécanisme de résolution des différends, il fallait nécessairement créer une étape préalable à l'arbitrage, c'est-à-dire effectivement en présence d'une convention qui impose une procédure préalable de règlement des différends, le tribunal arbitral examine si cette étape a été respectée par l'une des parties, et si cela n'est pas le cas, effectivement, l'étape préalable devra être engagée pour pouvoir satisfaire aux obligations. Si l'étape préalable a effectivement été engagée, le tribunal arbitral constate le cas échéant son échec. Donc, cela introduit effectivement la possibilité, en tout cas la nécessité ou l'obligation de passer par cette étape de règlement préalable si elle est prévue, enfin si cette étape est prévue par les instruments d'investissement. Et nous verrons comment cette étape est aménagée dans ces instruments d'investissement. L'adoption de l'acte uniforme, effectivement, élargit la notion de médiation en qualifiant de médiation tout processus, hein, quelle que soit sa forme ou son appellation. Donc, ce qui fait comprendre qu'au-delà de la médiation stricto sensu, toutes les autres formes de règlement amiable, notamment la conciliation, notamment la négociation directe, le comité de résolution des litiges, l'évaluation rapide et objective, etc., peuvent constituer des sortes de médiation. Surtout, l'acte uniforme introduit la possibilité pour le tribunal arbitral, effectivement, sur la demande ou sur invitation, à proposer aux parties de recourir à la médiation. Donc, c'est une médiation qui peut être initiée par le tribunal arbitral avec l'accord des parties. La médiation peut aussi être institutionnelle ou ad hoc, ce qui élargit effectivement les différentes possibilités offertes aux plaideurs ou aux investisseurs. Le recours à la procédure arbitrale ou judiciaire, en tout cas, est précédé nécessairement avec l'adoption de l'acte uniforme par le respect, en tout cas, des dispositions relatives à l'utilisation du recours amiable tel qu'il est prévu dans les dispositions pertinentes. Le recours amiable maintenant, dans une deuxième partie, est en lui-même, comme je l'ai dit, l'instrument pour prévenir les litiges d'investissement, en particulier les litiges d'investissement. En effet, dans les conventions bilatérales ou dans les conventions multilatérales d'investissement ou même dans les codes d'investissement, il est souvent prévu que les parties doivent respecter une période de règlement amiable, un délai de réflexion en général. Et ce délai de réflexion, il est prévu effectivement par les différents instruments que je viens de citer, notamment les codes des investissements et les traités bilatéraux. Si nous prenons le Code des investissements du Sénégal, effectivement, il propose la possibilité, avant tout recours, de procéder à une procédure de conciliation. Si nous prenons aussi le traité bilatéral entre le Cameroun et l'île Maurice, là également, il est prévu la possibilité d'un règlement amiable par consultation directe ou par négociation entre les parties aux différends. Et là également, il est ajouté un délai de 6 mois pour parfaire à cette situation. 10 ans après, le traité bilatéral Sénégal-Turquie également propose la possibilité pour les parties, effectivement, de faire des consultations et des négociations, mais surtout de bonne foi, in good faith. Et je pense que là également, au-delà du délai, c'est une obligation insérée dans les instruments. Dans ce traité, effectivement, il est donné un délai de 6 mois pour effectivement traiter ces questions-là. Donc, à ces tendances anciennes concernant les traités bilatéraux, on voit actuellement une modification, en tout cas une transformation de ces traités. Et actuellement, on assiste à la présence de traités qu'on peut qualifier de troisième génération, si on veut. Et ces traités de troisième génération, notamment, en tout cas, créent plutôt une gouvernance institutionnelle et la prévention des règlements des conflits. Et il serait utile pour les États OADA de voir comment gérer cette élaboration de ces instruments d'investissement dans ce sens-là. Notamment, comme je le disais tout à l'heure, en ce qui concerne les traités de troisième génération, effectivement, pour ce qui concerne le prototype ou le modèle brésilien, on sait que le Brésil est très attaché à ces questions de règlement des différents investissements. Leur modèle de traité bilatéral, en tout cas leur modèle en termes de règlement des différends, est de mettre en place un peu un mécanisme central d'ombudsman qui permet de recevoir les revendications, les questions posées et ensuite de voir comment les traiter. C'est ce qu'on voit à peu près dans le traité qui lie la Côte d'Ivoire et la Chine de 2020 et qui dit que les parties doivent essayer par tous les moyens d'utiliser des procédures amiables, par aussi recours à des personnalités neutres. Ces dispositions également du traité bilatéral Côte d'Ivoire-Chine prévoit un délai de 90 jours qui est beaucoup plus long. Et en ce qui concerne au plan régional, en tout cas, il est recommandé, ou en tout cas, il est possible pour les États OADA d'élaborer un modèle de traité qui sera applicable pour tous les États OADA. Donc, et prendre en compte effectivement ces innovations qui sont insérées. Puisque l'OADA s'occupe maintenant du règlement des litiges d'investissement. Et en ce qui concerne sur les innovations également à mettre en place, il s'agit aussi de retenir, en tout cas, un modèle de règlement qui intègre aussi les considérations économiques, sociales et environnementales dans la mesure où elles sont impliquées dans les nouveaux traités. Et enfin, instaurer un mécanisme procédural pour le règlement de ces litiges. Enfin, il faut promouvoir, dans le cadre de l'OADA, le recours au règlement aviable avant, pendant et après l'arbitrage, parce qu'effectivement, au cours de la période d'arbitrage, il se peut que, effectivement, qu'on puisse faire de la médiation. Donc, l'utilisation plus fréquente de la conciliation, l'utilisation de main d'armes, et ensuite, même après ou au cours de l'arbitrage, pouvoir trouver des modes de règlement amiables, notamment, par exemple, en ce qui concerne l'affaire État du Sénégal ArcelorMittal. C'était une affaire présentée devant la CCI, et bon, le tribunal arbitral avait déjà, dans une sentence partielle, fixé les responsabilités, et il restait à déterminer le montant des dommages et intérêts. Donc, bon, les deux parties, en tout cas, se sont mises d'accord pour pouvoir régler de façon amiable cette affaire et mettre fin à l'arbitrage. Donc, c'est l'utilisation de la médiation peut constituer, en tout cas, à tout stade, un élément qui permet, en tout cas, de réduire ou de résoudre les différents investissements. La dernière partie de mon intervention concerne les suggestions pratiques qu'il convient de considérer pour ces États de l'OADA. C'est, à mon avis, mettre en place une institution dédiée aux appropriates dispute resolution, parce qu'effectivement, il n'y a pas que la médiation. Comme je l'ai dit, il y a d'autres formes de règlement amiable, hein, l'évaluation neutre, le dispute board, etc. Et on voit qu'à l'heure actuelle, la CCJA ne dispose pas, en tout cas, d'un dispositif qui peut prendre en charge ces modes de règlement amiable. Donc, c'est une structure à créer, c'est une structure à mettre en place et à élargir au-delà de la médiation. La deuxième section, effectivement, elle concerne la formation des acteurs, hein, et la promotion du recours au mode amiable, parce qu'effectivement, plus on a de la capacité, plus on a des personnes ressources, plus on pourra utiliser ces méthodes. Donc, l'école régionale également de l'ERSUMA pourra prendre en charge ces éléments de formation. La troisième proposition, hein, c'est, à mon sens, la ratification de la Convention de Séoul sur les accords issus de la médiation. Certes, l'acte uniforme sur la médiation prévoit des mécanismes, hein, pour donner effet à cet accord issu de la médiation, mais pour donner plus de poids à l'OADA, il serait utile, et déjà un certain nombre d'États OADA sont signataires de cette convention, et ensuite il faudrait également, et c'est tout à fait possible au plan juridique, que l'OADA, en tant qu'organisation internationale, donc sujet de droit international, puisse, en tant que tel, adhérer à cette convention internationale pour donner plus d'effet au recours amiable au mode de règlement des litiges. En conclusion, je rappellerai deux choses qui ont été évoquées dans les panels d'hier. Un panéliste, c'est une panéliste d'ailleurs, Madame Tafa, etc., qui parlait d'africanisation du droit international. Donc, c'est-à-dire, à mon sens, comment la culture africaine peut, voilà, insérer ses valeurs dans le droit international. On le voit, et la médiation, le règlement amiable serait effectivement une voie, un apport que l'Afrique pourrait apporter au droit international, notamment au règlement des litiges d'investissement qui, comme on le sait aujourd'hui, traverse une certaine crise. Le deuxième élément de la conclusion, c'est toujours dans le panel d'hier, le professeur Benhamida s'est posé la question sous forme de boutade en disant qu'effectivement, a-t-on besoin de l'arbitrage? C'est vrai, on peut se poser la question, mais c'est vrai que l'arbitrage restera toujours, mais il faudra le compléter avec un usage accru des modes amiables de règlement des litiges qui constituent un moyen de prévention de ces litiges. Je vous remercie vraiment de votre aimable attention et reste à votre disposition. Merci à vous.
Merci Amadou de nous avoir expliqué comment les réformes récentes de l'OADA pouvaient être utilisées pour la prévention des litiges. Cependant, vous n'avez pas manqué de souligner que ces dispositions devraient être complétées et vous avez fait plusieurs suggestions en ce sens. Notre troisième panéliste sera Dr Ismaël Selim, qui est directeur du Centre régional du Caire pour l'arbitrage commercial international. En sa qualité de directeur, Ismaël a eu à administrer plus de 300 arbitrages selon le règlement du CRICA. Il enseigne également le droit privé international à Paris et il est membre de l'International Commercial Expert Committee de la Cour suprême de la Chine. Ismaël va examiner le rôle des centres d'arbitrage dans la prévention des litiges. Ismaël, vous avez la parole.
Merci beaucoup, Marie-André. Bonjour, mesdames et messieurs, ladies and gentlemen. It's a pleasure and an honor to speak in this distinguished webinar and conference. I am very thankful to SOAS University, Emilia Onyema, and to the CIMAC Center in Morocco. I wished I could be in Morocco with all of you, but as you have seen, these are the conditions of the pandemic. Today, I will speak about the dispute avoidance rules of the major African arbitration centers based in Africa. And if I have time, Marie-André, I can also say something about this ministerial dispute settlement committee in Egypt, which has also helped in the prevention of arbitration cases filed against Egypt, if we have time. I will start with the centers based in Africa. Most of the centers are usually focused on arbitration. So most of the institutions would have arbitration rules. Nevertheless, there are many institutions based on the African continent who have issued mediation or conciliation rules, or this is the case of the Cairo Regional Center, the Corsica. We have issued this year dispute board rules. So most of the mediation rules issued by the African centers would be inspired from the 2002 UNCITRAL Model Law on International Commercial Conciliation. Because as you know, the UNCITRAL mediation rules have only been issued in 2018. I can cite some of the centers having adopted mediation rules. I would mention Corsica, the Cairo Regional Center, since 2013, but also AFSA, the Arbitration Foundation of Southern Africa, AFSA, the Kigali International Arbitration Center, and the Nairobi Center for International Arbitration have also adopted rules in 2015. Also, other centers administer mediation rules like the CIMAC. The CIMAC is an arbitration and a mediation center, and also la CCJA in Côte d'Ivoire. They administer mediation cases, as mentioned, because the Acte Uniforme also regulates mediation. So all these mediation rules, as I have mentioned, are inspired by the UNCITRAL papers, but there are some differences that would remain. I would mention an interesting one. The Arbitration Foundation of Southern Africa requests from parties representatives not to be their external lawyers. On the opposite, the other rules of the other centers would not contain such a rule. Perhaps this is the reason why behind the AFSA rule is that the representative must have the authority to settle. Also, sometimes lawyers are not perceived as supportive of mediation. This is not always the case, but this is at least a perception. It is worth mentioning that mediation and arbitration are not opposite means of dispute resolution, but rather go along pretty well. Indeed, parties to international mediated settlement agreements are concerned about the certainty of the outcome should the mediated settlement agreement be breached, and enforcement sought before foreign courts. Thus, parties can also recourse at the same time to mediation and arbitration to guarantee the enforcement of the settlement. And this is what we call arb-med-arb. It's very well known and very well famous and adopted in Singapore, but it has also been adopted in other institutions. By way of example, the Corsica has issued in 2019 a guidance note to encourage parties to current or future arbitration proceedings to consider using the ARB-Med-ARB. And the guidance note explains the process and highlights that it is recommended that the mediator should not be one of the members of the arbitral tribunal. So the arbitration would be filed and then suspended, and then the case would be referred to an independent mediator, not from among the members of the arbitral tribunal. And if a settlement is reached, then the parties can go back to the arbitral tribunal and an award by consent can be issued. And this would guarantee the enforceability of the mediated settlement, which will take the form of an arbitral award and would be enforceable under the New York Convention. Also, I would like to say a word about the dispute board rules of the center, of the Cairo Regional Center for International Commercial Arbitration. A committee has been composed from, and all the regions of the world were represented in this committee, and this committee has elaborated dispute board rules for the Corsica. And we have issued these dispute board rules as recent as last August this year in Arabic and French, and we have drafted and elaborated a French version of our dispute board rules, and they are now under review. And a panelist of adjudicators would be available, so the parties are free to appoint their dispute board members even from outside this panel, but when the Corsica would be required to appoint, it would be from this panel of adjudicators. I would like to say, to shed light on the two types of dispute boards that can sit under the Corsica dispute board rules. We have the dispute adjudication boards and the dispute review boards. The dispute adjudication boards would issue decisions, and if there is no notice of dissatisfaction from such decisions within 28 days from their issuance, such decisions would become final, but they are binding from the beginning, and they would become final, and only the failure to implement such decisions can be referred to arbitration. So these decisions would be contractually binding, but in case of failure to implement them, if they become final because of a lack of sending a notice of dissatisfaction within 28 days, then the failure would be referred to arbitration. There is another mechanism that is also recommended, which is the dispute review boards, contrary to the dispute adjudication boards that I have just mentioned. The dispute review boards are recommended to parties and to governments because they issue non-binding recommendations and opinions. So the non-binding recommendation, if there is no notice of dissatisfaction from either party received within the 28 days from the issuance of the recommendation, then the recommendation will become contractually binding and final, and only the failure would be referred to arbitration. But if there is a notice of dissatisfaction issued by any of the parties within the 28 days, whether there is a dispute review board or a dispute adjudication board, then all the matter can be referred to arbitration because a notice of dissatisfaction has been issued timely. I would also want to focus on Article 13 entitled Dispute Avoidance. It's Article 13 of our Corsica Dispute Board rules. So it is an advisory function even if it's not mentioned in the original contract of the parties. So any dispute board may still provide an informal advisory opinion upon the joint request of the parties. And the dispute board may also, at its own initiative, raise any matter and endeavor to avoid any potential dispute and help the parties to solve the dispute at an early stage, even if there is not a dispute yet. But and this is done through the periodical visits that a dispute board does. So that's why we recommend that the dispute board is appointed as a standing body from the beginning of the project, and the dispute board is very suitable for long-term projects. So if there is a standing body that is appointed from the beginning of the project, and there are periodical visits that are undertaken, and under our rules, it is mentioned that these periodical visits should be done at least every 4 months, if not less. And that is how a dispute board can prevent the disputes before even they are referred to the dispute board. If the parties want to stop the dispute board's initiative, they can do so provided that they can jointly notify the dispute board in writing. Overall, dispute board opinions can pave the way for an amicable settlement, and actually dispute board opinions are a first insight of the probable outcome of an eventual future legal dispute. Thus, if the opinion is detrimental to one of both parties, the potentially losing party may even be more encouraged to seek for an amicable settlement. Last but not least, it is noteworthy that African arbitral institutions will be able to act as neutral party between the investor and the state only if their independence vis-à-vis the host state is guaranteed. This is also very helpful. So I would mention that there are 3 ALCO centers on the African continent that enjoy the immunities and privileges which ensure their independence vis-à-vis the host states. So the ALCO is the Asian African Legal Consultation Organization, and the 3 African centers which are ALCO centers are the Cairo Regional Center for International Commercial Arbitration, the Nairobi Center for the NCIA for International Arbitration, and the Lagos Regional Center for International Commercial Arbitration. If I have time, do I still have time, Marie-André? Did I exhaust my 15 minutes? I can't hear you. You are muted. 3 minutes, okay. I will just say a word about the Egyptian Investment Dispute Settlement Ministerial Committee that has been established after what we call the Arab Spring. So starting from 2011 and during the few years that have followed the Egyptian revolution in 2011, there has been a rise in the number of investment arbitration cases filed against Egypt for 2 reasons. Because of the effect of the revolution, which has a lot of effects on the investment contracts and the change of government and the allegations of corruption. And also because, and I echo what Emilia has mentioned, Egypt is one among the most countries that has entered into BITs. And in the past, there was not a real strategy and no BIT model agreement. So Egypt had signed 100 BITs. So it was the 6th ranked country worldwide. in terms of signing BITs, and almost more than 74 or 75 or 76, something like that, around this number were in force at that time, the time of the Arab Spring. So there was a rise in the number of exit cases, and today more than 34 exit cases have been filed against Egypt. So it is third in terms of ranking, the third country as a respondent state before exit. This is not to mention the cases that were filed against Egypt before the PCA or the UNCITRAL ad hoc investment arbitration cases. So the success of this interministerial committee, you know, it's difficult for a single minister to take the decision to settle an investment dispute, especially after a revolution and allegations of corruption and the multiplicity of corruption proceedings against former ministers of the former regime, whether rightfully or wrongfully. But this was the situation. So it was difficult for a single minister to take the decision to settle a dispute alone. So the aim of having an interministerial committee is that the decision is taken collectively. And this was very favorable to the investor, without need to withdraw from the BITs like other countries that withdrew from the BITs. Egypt did not withdraw from the BITs. So I can mention some figures. I would say that in terms of figures, we have around 15 cases that were settled by this committee amicably with foreign investors until 2017, and then additional cases were settled to reach the number of 26 cases. And also 13 commercial arbitration cases were amicably settled because of the role of this committee. And one ICC investment arbitration case against Egypt was also amicably settled by this interministerial committee. To add to these, one UNCITRAL ad hoc investment arbitration case against Egypt and 3 PCA investment arbitration cases against Egypt were amicably settled by this ministerial committee. So it's a great success. I would say much more than 50% were amicably settled because of the role of this interministerial dispute settlement committee. I have mentioned all what I wish to mention. I thank you very much for your kind attention, and I give you the floor. Thank you very much, Madeleine.
Merci Ismaël pour cet exemple très instructif et je dirais très pratique. Notre prochain speaker est Madame Lise Boseman, qui est directrice exécutive de l'International Council for Commercial Arbitration, ICA. Elle est également Senior Legal Counsel à la Cour permanente d'arbitrage basée à La Haye. Elle enseigne à l'Université du Cap en Afrique du Sud et elle est spécialisée en droit commercial international. Elle va se concentrer sur les leçons que les États africains peuvent tirer des travaux actuels du groupe de la CNUDC sur la prévention des litiges, et elle évoquera également la possibilité de création d'un centre consultatif à cet effet. Lise, vous avez la parole.
Thank you very much, Marie-André. Hello, everybody, and thank you to CMAC and to SOAS for the invitation to speak on this panel of such distinguished colleagues and friends. So I'll focus my remarks today on the work being done by the United Nations Commission on International Trade Law, UNCITRAL, in its Working Group 3 on dispute avoidance in the context of ISDS reform, and especially on the potential establishment of an advisory center on international investment law. So there are multiple reform options, both incremental and structural, currently being discussed in UNCITRAL Working Group III to address the concerns that have been identified with the current regime, including a need for guidance on effective dispute avoidance strategies. I think one of the more interesting proposals being considered at the moment is the establishment of this advisory center, which is intended to help states in implementing strategies to better prevent, identify, and resolve disputes before they turn into formal arbitrations. So in my few minutes today, I'll be proposing a potential approach to setting up an advisory center that is modest and focused in scope, and that, in my view, might best benefit African states. But first, why do African states need to develop better dispute avoidance strategies? Well, I mean, one banal reason is that in recent years, the relative share of ISDS proceedings involving African states has risen steeply. So just to take one stat, if you look at ICSID's most recent caseload stats in terms of geographic distribution of all ICSID cases, Sub-Saharan Africa is currently facing the third largest number of claims. And there are many reasons for this, which have been discussed in an earlier panel during this conference, and of course alluded to a few moments ago by Emilia in her introduction. So I won't go into that in much detail, but I do see a lack of overall cohesion in the practices of many African states in their approach to the investor-state relationship. So how do we set about creating that cohesion and efficiency? And I think that states should be thinking about a three-pronged approach. The first prong I would see is internal cohesion. As a first step, states should be taking stock of all their international obligations. And this includes compiling, centralizing, and making easily accessible all the states' investment treaties and contracts, and improving communication between government branches and between levels of government, if that's relevant, on all the obligations that states have undertaken. The second prong is external cohesion, and this prong is all about the investor-state relationship. So an excellent way to do this is to establish a central communication channel between the state and investors. And here we see UNCITRAL talking about establishing a lead agency, an investment ombudsperson, or some similar mechanism. And the third and final prong of this approach is normative cohesion, which would consist of a periodic review of a state's legislation to ensure that it aligns with its international obligations and investment treaties. Would also consist of a periodic review of international obligations to make sure that they're consistent with the state's own national policy objectives, in this way avoiding inconsistencies between internal and external priorities and obligations that might potentially lead to conflicts. So this is the basic framework that I'll use in looking at the UNCITRAL Working Group III dispute avoidance proposals. So taking a step back, the state members of the UNCITRAL Working Group have expressed general support for preparatory work on establishing an advisory center. They did this in October of last year, and in response to that, the UNCITRAL Secretariat then went ahead and published initial draft provisions on the establishment of an advisory center. Now, unfortunately, the time to sort of comment on that in writing has passed. That was in September of this year, but there will be an opportunity for African member states of UNCITRAL to comment on those provisions next time UNCITRAL actually meets in February of next year to comment if they haven't done so already. So what do these provisions do? So the draft provision 1 by UNCITRAL sets out the purpose of the advisory center and its operating mechanisms. And it proposes to offer advisory services in matters relating to international investment law and ISDS proceedings to either all states or to developing states or to least developed states, or a combination of those, and possibly to small and medium-sized enterprises, SMEs, which are collectively referred to by UNCITRAL in their paper as the beneficiaries of the center. As currently proposed, the Advisory Centre would comprise two main arms. The first is an assistance mechanism, which would provide the services in whatever scope is finally agreed. And the second arm would be a forum for the beneficiaries of the centre to share information and best practices among themselves. And then UNCITRAL, in its draft provision 2 on services, which is really the crux of the debate right now in that forum, proposes that the Advisory Centre should provide pre-dispute and dispute avoidance services to state beneficiaries that might do three things, which I alluded to earlier. First is to support states in establishing some sort of a lead agency that would be responsible for centralizing and making more coherent ISDS matters within a state. The second is to help to set up conflict management systems within a state, including early dispute prevention policies and alerts to potential disputes arising. And third, to advise on the management of disputes between local investors and host country governments at the national level in order to resolve them locally before they turn into formal international conflicts. So what does UNCITRAL see these measures looking like in practice? So first, with respect to establishing a lead agency, this strategy consists of identifying a single national entity that could establish a single channel of communication between all investors and the state, and aim to ensure consistent implementation by all the relevant government ministries and those tasked with contract management in the implementation of investment obligations. This agency could also coordinate with other government agencies to develop overall dispute prevention policies. And some of the states that have reported to UNCITRAL on this practice have used different models, such as an investment ombudsperson, that's the Korean model, or an institution responsible for dispute prevention and management within a certain ministry, which as is done in the Ministry of Trade in Colombia, or again, as part of a sort of larger system, such as the Peruvian system for the coordination response of the state across the board. States have also reported to the working group that in addition to establishing a communication channel with investors, an important step in managing conflicts is first to start off by systematically compiling, mapping and evaluating the state's investment contracts and treaties, as well as past ICS cases already brought against the state, which would contribute to greater internal cohesion. And a lead agency could take the lead on that and make sure information is shared across all sectors and across all government agencies. Next, the UNCITRAL Secretariat notes that timing and early management of conflicts before they escalate into disputes can play a big role. And here it advises on strategies such as setting up alert mechanisms to allow states or state agencies to become aware of grievances as early as possible. Before they become formalized. In the same vein, if a state notices over time that certain kinds of contracts or investments in particular economic sectors are more prone to disputes, the lead agency or whichever agency or office is ultimately tasked for playing the monitoring role could pay closer attention to those sectors, thereby increasing this both external and internal cohesion. And once a dispute or a grievance is known to the state, dispute avoidance then becomes about managing the problem at the local level before it escalates into a formal dispute, which of course is, as we all know, is inevitably lengthier, more costly, and often more politically or socially charged than some sort of a negotiation process. And one option here might be to provide for administrative review of a problematic law or a measure in a host state. So in this way, careful management at all these levels could be an important step to achieving normative cohesion between a state's national policies and the measures it takes on the one hand, and its international obligations on the other. But at this stage in the UNCITRAL discussions, it's unclear exactly what the role of the Advisory Centre could be during this early stage of dispute avoidance. And that's partly because one critical discussion that hasn't yet been resolved within UNCITRAL is what the overall scope of the services offered by the Advisory Centre should be. So some of the discussions, some of the proposals on the table in the form of comments by member states cover issues such as, should the advisory centre offer only those pre-dispute and dispute avoidance support services like the ones I've outlined? Or should it go further and offer mediation and ADR services? Should it offer policy advice to states? Should it focus on capacity building? Should it offer support services to states in ongoing live disputes? Or should it even go as far as offering full legal services in the form of representation in ISDS cases? And views by member states so far are very mixed. In the very early stages, early African commentators, including Morocco and South Africa, generally supported dispute avoidance as an area worth exploring in the overall context of ISDS reform. But more recently, we see that states who have actually commented concretely on the UNCITRAL Secretariat's initial draft provisions for the centre have seemed less inclined to make dispute avoidance the primary focus of the advisory centre services. Instead, they seem to be leaning towards a structure that could offer legal representation in live ongoing ISDS proceedings, essentially some sort of funded, possibly pro bono law firm model for under-resourced states. And of course, many states in their comments have also highlighted the importance for the advisory centre to work in partnership with beneficiary states in the interests of capacity building. So in this vision of some sort of multilateral, specialized, externally funded law firm model, dispute avoidance becomes only one part, and probably in practice, a fairly small part of the services offered overall by the centre. And that's a vision that I really am having some trouble with. There are so many complex considerations in potentially setting up and running any sort of advisory centre, including what exactly the legal structure should be, who the beneficiaries should be, the membership of the centre and its financing, the sustainability of financing to make sure that there's continuity of services offered throughout the lifespan of a conflict or the lifespan of an arbitration. Issues such as independence from its funding parties, avoidance of conflicts between beneficiaries, particularly if a model is adopted that includes both states and SMEs as beneficiaries. And of course, the need to avoid duplicating services that are already offered by other agencies, such as UNCTAD and the ALSF and some others. So the broader the scope of the services offered, I think, the more expensive the centre will be, the more complex the structure, and potentially it may become less sustainable. Unfortunately, as far as I've been able to ascertain, no African state so far has submitted written comments on these concrete proposals by UNCITRAL. There is still an opportunity, as I just mentioned, in February 2022, there'll be renewed discussion on the scope of services and the structure and the financing of this advisory centre. There are 16 African states that are currently members of UNCITRAL and many more that are observers. All have the right to actually make comments or observations during those sessions. And I really hope that we'll actually see a lot more sort of focused thinking and input from African states during those sessions. But my thinking would be that in making those sorts of interventions and thinking about this area in general, African states looking to explore dispute avoidance strategies with or without the assistance of the advisory centre should consider some sort of approach that best advances this goal of achieving cohesion internally, externally, and in a normative sense. And I think the most effective way for a multilateral advisory centre to support African states in achieving this cohesion would be to adopt the following approach. First, make it very clear and define the scope of services that will be offered by the centre upfront. Second, keep that scope limited, at least in first instance, to true dispute avoidance services. And those services could be quite varied and include, for instance, advice in setting up a national lead agency, mapping existing treaties, contracts, and claims, advising on strategies to resolve investor dissatisfaction before a formal dispute arises, perhaps providing a clearinghouse function, so connecting states with the advice they need through keeping lists, for instance, of pre-approved advisors or law firms or academic support. and building up a comprehensive resource library on general policy issues that could be used by both states and SMEs without running the risk of creating conflict issues, as it would if the Centre was actually actively advising parties in ongoing conflicts. And then finally, after scoping the Centre properly, states, I think, might consider setting it up in a phased way. You know, for instance, starting off with a narrow and clearly defined scope of services, evaluating after a period, say 5 years, to see whether the Centre has in fact been effective in delivering those services, and then investigating whether there is political support and funding to expand the scope of those services. So in effect, number one, clarify the vision. Number two, start in a modest and focused way. And number three, potentially expand later. Thank you, Marie-Andre. I'd be very interested to hear any thoughts and questions.
Merci, merci Lise pour cet exposé très clair avec beaucoup de suggestions et de conseils. Je vais maintenant passer la parole à Dr Hussein Haeri, qui va traiter de l'importance d'une approche organisée et cohérente entre les différents manquements des gouvernements dans le traitement des investisseurs. Il nous donnera également quelques conseils pratiques tirés de la jurisprudence en matière d'arbitrage des traités d'investissement. Dr Hussein Haeri est solicitor advocate of the Senior Courts of England and Wales. Il dirige le département de droit international et également le département d'arbitrage international de son cabinet. Il conseille différentes personnes, que ce soit des gouvernements ou des organisations internationales, et dans, je dirais, presque tous les domaines vus au cours de cette conférence, que ce soit le droit de l'environnement, les droits humains et tous les autres sujets qu'on a vus. Docteur Hussein, vous avez la parole.
Merci, Marie-Andre, and thank you very much, Emilia and SOAS and CIMAC for the kind invitation to join you today. I will share the screen because I have a presentation which I would like to run through. If you can now see it, and in particular, it's the role of coordination in preventing investor-state disputes. So this is to lead on from Lise Boseman's overview of the three areas. This is really a focus in on the first of the three areas that she identified, which you might call internal cohesion. Internal within the state, in terms of how it responds to and deals with issues before they become disputes, and once they are disputes, before they become international arbitrations, with the various cost and reputational and financial consequences that often flow from that. So just to start, before we look into some of the legal issues, dispute prevention is, of course, very important, both in terms of attracting as well as retaining international investment. And you have on this slide references to a recent World Bank report, which speaks of investors divesting from developing countries because of irregular government conduct in approximately 25% of cases. So even if one accepts that in some of those instances, there is a thought through government policy to regulate in a certain sector, or even to expropriate, one would hope with compensation, an international investor's investment, that still leaves many of these divestments resulting from a lack of coordination among different state entities. One state entity may give certain rights and another state entity may take them. And it's that lack of coordination and consistency that is something that can be a focus as a matter of practice in order to minimize exposure to disputes and cases, whether they're commercial arbitration or based under treaties or national legislation. And this second bullet point addresses what underpins many of these disputes. Aside from regulatory changes, many of these disputes are found to have arisen from a lack of transparency and predictability of government agencies. And those two issues, transparency and predictability, are part of the fair and equitable treatment standard, which is a very common treaty standard in bilateral and multilateral investment treaties. And very often a lack of transparency and predictability will also implicate contractually agreed terms. And so how do you enhance that transparency and predictability? And essentially what I'm going to be focusing on is the importance of having a centralized state repository of knowledge for coordinating on issues that can give rise to disputes, not just an ombudsman who deals with the disputes as they arise in an early stage, nor what is often a separate state entity that negotiates and agrees the treaties, nor what is often a third and separate state entity that manages the litigation that arises from the disputes, but an entity which is established that has functionality in all of these respects, so as to bring the knowledge of who are the investors, what are the issues they face in the context of the legal obligations, as well as potential dispute resolution consequences. So that's going to be where I will come on to focus to address this issue of transparency and predictability. Now, these issues arise in part because, as a matter of international law, the state is a unitary actor. And this is reflected in the International Law Commission articles on state responsibility. So although one may see different ministries, different departments, agencies, and state entities, each have their own sphere of influence, their own legal frameworks, as a matter of international law, it is the state that is responsible. And so where you're dealing with the conduct of a state organ, it's the state that is legally responsible, whether that organ exercises legislative, judicial, or executive functions, and whether it's an organ of the central government or of a territorial unit. And this is why it's so crucial to have an organization which has visibility on what's going on at the various levels for major projects and investments, because it's quite often the case that conduct at the territorial level, even at the city or municipal level, let alone at the state level, can give rise to international treaty claims, for example. And the federal state authorities or central state authorities, as the case may be, are often unaware until very late of quite what's been going on. And there's a lack often of awareness of how actions at that territorial level, for example, can give rise to international treaty responsibility for the state. And of course, the ILC articles also provide that there is state responsibility for entities exercising governmental authority or under the effective control of the state. So if the state is a unitary actor, it's an actor with many hands. And what one hand gives, another hand may take. And this is in fact the fact pattern of many investment treaty and international disputes. And it's that lack of coordination which gives rise to what are disputes that might otherwise better be avoided. These are not necessarily disputes arising from a clear regulatory decision and policy. They're often disputes that arise from a lack of carefully thought through consideration, calibration, and coordination, what Lise referred to as internal cohesion. And one can see a number of investment treaty cases that have addressed this exact scenario. So there is a quote there from the Tribunal of Encana and Ecuador, where it said that one arm of the state cannot finally affirm what another arm denies to the detriment of a foreign investor. And the inverse could also be said. One arm of the state cannot deny to the detriment of a foreign investor what another arm affirms. And so in order for that not to happen, one has to know which arm is doing precisely what, with the consequences that can flow from it. Now, we see a recent exposition of this principle in the case of Arif and Moldova. And it highlights how we're not just talking about different ministries or departments, or even the central government compared with actions of the territorial or municipal government. It's often also different organs of the state. So the executive may do one thing, and the judiciary may do something very different. And that in turn can give rise to breaches of treaty commitments, because it's the state that's responsible for the actions of all of the organs. And in this case of Moldova and Mr. Arif, what was found is that the civil aviation authorities had encouraged an investment in the airport, in particular into the duty-free sector, while the courts in Moldova had found the same investment to be illegal. And the tribunal found that that type of inconsistency in itself amounts to a breach of the fair and equitable treatment standard. Now, many of these cases refer back to an earlier authority, MTD versus Chile, going back more than 15 years. And this was a project run by a Malaysian investor in Chile, and they were going to be developing a model city. And they had approval from the Foreign Investment Commission of Chile in order to do that. However, subsequent to making their investment, the authority that was responsible for giving permissions for rezoning from what was agriculturally designated land to being land that could be used for urban development refused to give permission for that rezoning. And what the tribunal found is that the approval of the investment by the Foreign Investment Commission for a project that was against the urban policy of the Chilean government was in itself a breach of the obligation to treat the investor fairly and equitably. So this is exactly the sort of scenario where it's very important at the stage of the investment for the different state entities that are going to interact with the investor to be aware of what decisions have been made by other parts of the state and what consequences can flow from that potentially if you have a directly contrary decision made by another emanation or part of the state, even if that's lawful as a matter of national law, because it can implicate international obligations, whether under contracts or treaties. Now, bringing it back to Africa and also to cases that I have been involved with, one can see this illustrated in practice. So the first example there is one of local authorities failing to comply with directions given by the Solicitor General of the state at the federal level not to undertake certain actions. And despite those directions, actions were taken by the local authorities, which resulted in a breach of the investor's rights under a treaty. So this highlights the importance of internal cohesion and information sharing in terms of the territorial units of the state, as well as the central state authorities that are ultimately responsible for dealing with the international arbitrations that ensue in this kind of a context. The second example is of a different sort of cohesion. It's parallel ministries taking different approaches. Of course, there is sometimes an issue of even territoriality within ministries of taking certain positions. But I think what's very important is that there is a joined up process when dealing with an investor, because otherwise that can also give rise to international findings of violations, whether of contracts or treaties. And so in this second case, you had a situation where one ministry approved a project, and executed a contract to move ahead with it. And there was a parallel contract that was to be signed by a ministry that dovetailed with that initial contract. The second contract was not signed by the ministry that was not supportive. And that had implications for the first contract, which was then found by a commercial arbitration tribunal to have been breached with a consequent award. And the third example is a contract entered into with an investor following a tender process, including with respect to land being allocated for activities, and then subsequently that designated land not being made available to the investor due to the intervention of another ministry. So these are illustrations of the importance of having internal cohesion and joined up thinking when it comes to dealing with international investors, lest it gives rise to breaches either of treaties or of contracts. So some practice points to take away from this, and many echo and really reiterate what Lise had mentioned, which is ensuring that ministries, government agencies, and entities are aware of the state's international obligations in respect of foreign investors. I think this point really cannot be emphasized enough. The importance of training on international law, on the dispute resolution processes, as well as how investment treaties have been interpreted in the cases, because that can be very influential in terms of other cases. And it may come as a surprise to many in government, even at the central government level, let alone often at the territorial level, if I can put it like that, that their actions can give rise to a binding and enforceable international award, even if in some cases they are done in a way that complies with local law, and that's the case even for actions of the local courts. Again, it would be a surprise to many that the actions of courts can be subject to consideration and adjudication by an international arbitral tribunal. Not, of course, that international tribunals are appellate fora of national law issues, but nevertheless, national court actions and decisions can give rise to international treaty obligations. So training and an understanding of how actions can fit within this international framework, I think is really crucial. The mapping of information, understanding what the state's obligations are. And Professor Onyema spoke about making promises that the state cannot necessarily always abide by. I think what's crucially important as well, of course, and very much agree with that, is to understand what promises have been entered into, to understand the scope of the contracts and the treaties, and what that means in the context of specific projects. Because it's really only when you put the obligations and the projects together and understand how the projects are developing and who is interacting with the investors, that there are, communication flows that can then be useful to nipping disputes in the bud before they become fully formed ones. And I think what is important in this also is to designate a lead agency that's responsible for coordinating on this and has the authority to do that. Because, as I say, very often there are silos. You may have some ombudsman who deals with a certain amount of disputes, but a different entity that drafts the treaties and a different entity that's responsible for defending the state in the event of arbitrations and knows the cases better because they deal with the cases every day. It's what's really important is to have the cases and the way they're interpreted inform the thinking, not just at the treaty drafting stage, but also at the investment making stage and complaint stage, because ultimately that's the direction that they will go in otherwise. And developing early information sharing with that lead agency, as well as an early alert mechanism when there are projects in sensitive sectors, large projects that are starting to become acrimonious or potentially so, with a view to resolving disputes and making settlements as early as possible when that is indeed feasible. So I will pause there and thank Marie-André for chairing the session, and happy, of course, to take any questions if there are any.
Marie-André, you're on mute.
Merci Hussein pour cette brillante présentation. Et merci aussi à tous les panélistes parce que je pense que chacune de ces présentations, sous un angle différent, peut être étudiée et permettre aux États et à ceux qui les conseillent de trouver les méthodes pour prévenir les litiges ou lorsque les litiges sont nés, d'éviter d'aller au contentieux. Donc, toutes ces présentations ont été fort utiles et instructives. Je vais maintenant voir, je crois qu'il y a une seule question. Il y a une question pour Emilia. Emilia, est-ce que vous êtes avec nous? Est-ce que vous pouvez répondre?
Thank you very much. Thank you, Sarah, for your question. I don't know the answer to the question. I don't know how we're going to open those closed doors. I think we can continue to knock. So one of the ways that we're knocking is what we did at this conference, which was we had the General Council of the African Union. And we made it really clear that it's important for the African Union to consider having an academic, something similar to an academic forum. And we shared that experience. I know speaking for myself, that knocking on my own home country government doors, I know the Attorney General, knocking on those doors, speaking to them, the door hasn't opened. I think we have to be, for those of us who do not live on the continent, we also need to be sensitive to some of the concerns that people on the continent might have. So the only thing I can say is we must keep knocking, and we must keep publishing, we must keep sharing as we have an opportunity to help, and hope that those who we're speaking to actually hear what we're saying, and then the difference will be made. Other panelists, please join in providing thoughts on this question.
Qui veut ajouter, compléter ce qu'a dit Emilia? Personne? Amadou. Amadou, vous avez la parole.
Oui, merci beaucoup, Marie-André. Afin de compléter effectivement ce que disait Emilia, je pense que le secteur privé, les organisations non gouvernementales, la société civile, nous l'avons évoqué dans le panel d'hier. Effectivement, il y a une nécessité de transparence, il y a une nécessité de circulation de l'information, il y a une nécessité d'une approche inclusive, etc. Donc, en matière d'investissement, il faut élargir le champ des acteurs. Et je pense que les organisations non gouvernementales, la société civile, sont partie prenante, hein, de même que les juristes, de même que l'administration, parce qu'il s'agit fondamentalement de ressources naturelles. Et souvent, et c'est le cas au Sénégal, les ressources naturelles, du point de vue de la constitution sénégalaise, constituent des ressources du peuple. Donc, toute composante du peuple devrait avoir son mot à dire quant à l'utilisation de ces ressources naturelles. C'est ce que je voudrais ajouter sur cette question de participation des organisations non gouvernementales au règlement des litiges ou à la prévention des litiges. Merci.
Merci Amadou. Emilia, est-ce que j'ai encore quelques minutes pour poser une question? Alors moi, quand j'ai préparé mon diplôme de médiateur, j'ai fait un mémoire sur la médiation en investissement. Et je voudrais soumettre aux panélistes une préoccupation que j'avais pour recueillir leurs opinions. C'est le problème de la confidentialité dans la médiation. Dans les pays africains où on reproche à l'État de manquer de transparence, où il y a toujours des suspicions de corruption ou de collusion, est-ce que la confidentialité de la médiation n'est pas un obstacle à son développement? Ne faut-il pas aménager la confidentialité de la médiation dans le cadre de l'investissement? Je ne sais pas si un des intervenants voudrait commenter cette préoccupation.
I'm happy to offer some initial comments on that. I think it's a very interesting question. I mean, the concern that comes to my mind is whether if there was no confidentiality and the mediation was a purely open process, it might hinder states as well as potentially investors from engaging in it in as full and flexible a way as they otherwise might, because of a concern that in doing so, this could somehow weaken their position in terms of public perception. And that, I think, might result in mediation potentially being less effective than more effective. So it's not a statement against transparency, but I could imagine that it might have a slightly chilling effect on the efficacy of negotiations and mediations if there was no confidentiality. But this is just one perspective.
Can I just sort of say that for me, I agree, but again, we need to define, or for the state and the investor to define the purpose. What's the essence of the mediation? So if, for example, the investment treaty calls for mediation so that it's part of the formal dispute resolution process, I think that's a different question. But if, for example, the whole idea of entering into that mediation or trying to settle is to avoid, as Hussein had said earlier on during his presentation, to avoid the ending up in arbitration in the first place, then I think it needs to be confidential. It has to be confidential because it's still part of the, if you like, pre-adjudicatory process. The idea being, we want to participate in this in good faith to ensure that we do not end up in arbitration. But if it is part of the process, so if it's a tiered dispute resolution mechanism that they are using, it will be very difficult to say that it should be confidential. But then that, as Hussein has said, the danger with that is the lack of good faith. So let me not say bad faith, but the lack of good faith, because the parties will be hedging, not knowing whether we're going to resolve this dispute in political interests. And maybe this is one of the areas as it relates to investment law and civil society organizations, where the activism of civil society organizations may not be doing states any good. And I think there's a lot of pressure that civil society groups put states under when they have their protests and things like that. We saw that with the negotiation of the TTIP and co.
Merci, Emilia. Un autre speaker voudrait donner son point de vue sur
Yes, I would like to link this with a question that has been asked to me by Reem Fakhoun, one of the participants, is about whether the statistics that I have mentioned were public or not. So I approve, of course, Hussein and Emilia, that confidentiality is the essence of mediation, and it's difficult to convert mediation into a transparent process unless all the parties have agreed so. But perhaps the statistics of settlements a country or a state may consider of having them public. So the question of Reem, whether the statistics I have mentioned are publicly available or not, you will not find them on the website of the Ministry of Justice, for example, but I requested them from the Ministry of Justice, and they gave me, I explained that it is for the purpose of this webinar, and they submitted these statistics to me. I just want to correct myself about the number of exit arbitrations against Egypt amicably settled. They are 15 and not 24, as I have mentioned, so I correct myself. I also see that the Vice Minister of Justice speaks about these statistics publicly in different conferences. So I can say they may be available in conferences like these, but they are not on a website. This is to answer Zrim's question.
Merci Ismaël. Je crois qu'on peut clôturer ici maintenant. Emilia, je vous redonne la parole.
Thank you. Merci beaucoup. Merci, obrigada. Thank you so very much, Marie-Andre, for the discussions in the panel. Thank you, Hussein. Thank you, Lise. Thank you, Ismail. Thank you, Amadou. And thank you to myself as well for contributing to the discussions of the panel. And this brings us to the end of our conference and what we have engaged with. I just want to remind us the title of this conference was Navigating the Interests of African States in International Arbitration and Mediation. And we've sort of engaged with that, set out the context, looked at the instruments and the documents that African states get them sign up to. We've looked at the dispute resolution processes. We've looked at mediation, and we've concluded with the need for dispute avoidance. And so I am very grateful to all the speakers, particularly to our keynote speaker who set the tone for the conference. Marie-Andre, Nagla has a question in the chat while you're looking at at her notes in the chat. I forgot to say to our panel to actually set a bar for us, because all the other panels, we asked exactly the same first two questions in the poll, and they all scored 100%. And they all had professors on those panels. And I said, I don't think any professor would give their students, especially law students, 100% of the marks, but they scored 100%. On our panel, we have Lise Boseman, we have Hussein, we have Ismail, we have Amadou. All of us teach in this area. And so let's see what we've done. So the poll results are in, and professors, you'll be very happy and very pleased to note that for the first question, did the speakers clearly address the topics? You actually all scored 100%. So well done, professors. And then the second question, were the topics useful for your practice or education? You also got 100%. So we're not doing too badly at all. Maybe there should be more than 100%. But anyway, Hussein will not agree with me. Okay, 100%. The third question, do you think it is weak for a state to avoid disputes? We had 35% said yes. And that, I think, is something we do need to unpack a little bit more. If 35% of those attending our conference think that a state that embarks on dispute avoidance, that is an evidence of weakness. So can you imagine what the politicians will be saying to themselves? And 65% said no, that they do not think that it's an evidence of weakness on the part of the state. So that concludes our poll, and well done. Many congratulations to the panel. So we're going to quickly move on to what would happen next. Remember that this conference series now, we go to different countries, and we didn't get to go to Casablanca this year, but maybe we'll go some other time. So we have Ghana would host our conference in 2022. And our conference in 2022 is being organized by Kizito Bayu and colleagues that do arbitration in Ghana. So I'm going to hand over to Kizito to tell us a little bit on what we should expect. Kizito, please.
Okay, thank you, Emilia, for this wonderful opportunity. It's a wonderful opportunity because COVID struck in late 2019, and since then, those of us who have been in-person participants in SOAS really missed the opportunity to gather around our conference theme and our discussions. It is my pleasure to announce that Ghana will be the first in-person conference. We don't even want to consider it being partial, online and partial in person. We want to designate it as an in-person conference, but we will make available persons who cannot travel for one reason or the other. It is therefore my pleasure to invite all of you to next year's SOAS conference in Accra. As you know, Emilia, I said, Ghana is the gateway to West Africa. So we are inviting you into West Africa through Ghana. We would welcome each and every one of you who has taken part in all the previous SOAS conferences. I can't tell you how much I've missed all of you have seen in various conferences, and we are looking forward to having you in Accra. The conference is going to be in the first week of November 2022, around the same time that the Africa Arbitration Association will be organizing its conference. Definitely SOAS will put out the conference details, but please let us gather as we have done previously before COVID hit. And let's have fun around our conferences. On that note, Emilia, I wish I will see every one of you in Ghana November next year. Thank you.
Thank you very, very much, Kizito, for that invitation. We are all very much looking forward to being able to gather together in person. And I'm sure that Kizito would also, we would put out a call for papers. And what we normally do is we also, in addition to the call for papers, we approach some of our colleagues and invite them to speak on the panels. So we hope that once we call upon you, you would graciously respond positively. It's left for me to say a huge many thank yous. So there are lots of people to thank. I have to start with CIMAC. It was last year that Hisham, who is the Secretary General of CIMAC, accepted our invitation to host our conference. And they have just been behind the scenes doing all the moving things around. Initially, we thought we could meet in Casablanca, which was why we moved the conference, hoping that the pandemic would be over. And then, unfortunately, the third wave hit in Morocco. And so we decided if we're going to do this conference this year, we have to do it virtually. And it's worked out really well, too well, actually. It's really, really worked out well. Our panels have had sufficient time to engage with their discussions. We were not chasing people, come back after tea break and lunch, come back, people were here. And it's been great. And it's just to say a huge thank you to Hisham, to Yasmin, to Zuhair, to Othman. A huge thanks to the SOAS bit part of the administration, to Iman, to Magdi, who is our social media guru. He's a young man who really likes social media. So he's been putting all sorts of things on the conference app, on Twitter, and doing all the razzmatazz for us. So Magdi, thank you so very much. We're very, very grateful again to our sponsors, to our partners, and to you, our participants, our attendees. Thanks for attending. To our speakers, our chairs, to our keynote speaker, everybody, thank you. And so we look forward to seeing you next year. And that ends our conference.